Temple of Justice here this morning. I'm here along with my colleague, Dr. where this morning this afternoon at about exact 12:06, we all assembled at Criminal Court A to hear the ruling in the motion to suppress that filed by the defense team on Tuesday in a 33-count motion. But prior to that, one of the lead lawyers, Councilor Arson, had a submission to spread before the court on grounds that they wanted the program or they wanted the proceedings to be televised. And so he quoted in this specific reference to Councilor Copar's proceeding at the level of the Supreme Court, when he said the court authorized journalists and others to televise the program. And so on based on that because it's a public interest for them to know. And so the prosecution team led by Montreal County R&G Councilor Rachel Scott insisted and said that's a rule governing the court, not only criminal court A, but all courts that no televised or sessions should be held in court or photographs be taken. And so both of them argued about that. They dismissed that motion because it was contemptuous. And so Judge Willie came back to rule that the same rule 11 that the Montreal County Chief Councilor Rachel Scott was the same rule 11. Judge Willie quoted and said that that and the code is no exception. At a point in time, even more journalists that go about doing secret recordings and even discussing the matter publicly in court, especially about their own opinions. He said it's not against the rule, and so the journalists are caught doing that. If the attention is being brought before the court, actions will be taken. So based on that, the rule that he said the court was no exception, he denied that motion for the entire proceedings to be televised because it says public interest. And so Judge Willie also mentioned that is the unique case in other cases, and so it shouldn't be a particular case that people should say or the defense team should have grounds to say that particular case should be televised, because if they have these people who think that they are taking interest, and that is also of disrespect to the court. So he noted that this court, criminal code A, is no exception to Rule 11 that was brought, that was provided or brought into law by the Gloria Scott bench, which of course Judge Wilkins, right, because one of the lead lawyers, Councilor Copar's team, was also part of that bench. So based on that rule, he denied that motion. And so the motion to suppress that was filed by defense team 2 days ago, the territory count, he reserved ruling, and he told the court that one thing he told between both teams' argument was the issue of torture and sodomy. And so he ordered the clerk of the court to do a communication to JFK Hospital to have those defendants that alleged that they were tortured and sodomized to come up with a report on or before September 10th on Tuesday, and at which time on Wednesday he will do. But the defense team lawyers, Councilor Arthur Johnson, resisted vehemently to what the judge said on grounds that JFK is a government hospital, and so they wanted an independent hospital to conduct the examination on those defendants that alleged that they were sodomized and tortured. In fact, he also included psychiatrists and psychologists to be part of the medical examination team. And so there where we are. When we come back next week, Wednesday, hopefully, the judge will be ruling based on the results from the hospital.
Yes, Mr. Tobe, you were also in court today, and I just want to give our audience a vivid description of the court today, who are those who are in court, both the defendants and even those who are going to follow the case.
I think it was a jam-packed court today, as we all would expect. Families and relatives are all there, including the people who are in interest of the case are all coming to court to see how the entire proceeding rolled on. As you may be aware, that those that is facing criminal prosecutions are high-profile people, especially the former prosecutor J. Copa and some lawmakers from the district at 15 and 16, and others are lawmakers are from other districts, especially across the country. So they are all in the trial. So you expect public interest. And what also to make the court jam-packed today, that everyone was waiting to see what would be the ruling of the judge today at the submission that was made by the defense team yesterday to suppress the entire evidence that was given to them by the prosecutors. And there is the evidence that they still believe that is the strength that they use and even obtaining the true bill against the 14 defendants, including the speaker, meaning that the indictment has on the grand jury. So this message that has been said yesterday, meaning that they have nothing again to took an exception to the Supreme Court if all the judge was ruled against them or any of the parties. Definitely the matter were taking flight to the Supreme Court. And as the party directly said, we all were anticipating that the ruling today when the defense team made a submission to the court to televise the entire trial. And I think Judge Roosevelt Willie was not in error because there are a lot of submissions that have been made in court talking about the Klan trial, the labor money case that was involving Councillor Barney Sherman and others. And Councillor Johnson was one of the prosecutors in that case. He made similar applications before the court at the time, and that applications were denied based on the laws that they have now forwarding all courts in terms of televising trial opening. And for the Supreme Court, that is the big court, and they can suspend that and have that done, but for the subordinate court to do that, it would be very difficult because he made reference to the Supreme Court as some ruling that they have been having there and been televised in the Supreme Court. But you cannot compare the Supreme Court with the subordinate court because it is the Supreme Court that made these rules, the general rules of court. And so if at all they want for trial to be televised, then there will be a circular or there will be some mandate given, and that will form part of the same laws that the lower court is relying on to make these things. What is what happened today, even though many expect the court to move on the motion to suppress evidence, what is happened today? And you saw the atmosphere. There was great result. You saw some exchanges from the defense team and the judge, not bitter exchanges per se, because lawyers know that the court, they are arm of the court, so they will never disrespect the court, especially when it comes to procedure.
Mr. Tobela, you rightly said the BKR motion today in court was the issue of televising the whole case because it's a public interest case. Looking at those involved, Mr. Tobe, Councillor Ponati Kofa once says a minister will stay without portfolio during the Malansali regime, and later on he became a representative. He served as deputy speaker during the George Weah regime. Later on he served as speaker before you were removed by colleagues and due to trust of lack of evidence, lack of trust by his colleagues. Now he's currently in court in relation to the Arson on the Capitol building, which is the seat of lawmakers from various countries. Today, after that submission was made by Councillor Arthur Johnson, the atmosphere changed. You have followed cases, notable cases. What do you make of the atmosphere by the defense lawyer, Councillor Arthur Johnson, after the motion was denied by Judge Willie?
When you listen to him, no defense team will feel good, especially when you file an application and they have been denied. You would hear them have given the response. But one best way to do it is to go on what we call a remunerate. That means to appear before the judges in Chimon. And I believe that probably they could take flight.
So meaning as they stand on, the defense team can take a flight to the Supreme Court to justice in Chimon?
Of course, because they had a submission today, another new submission that they want for the Klan case to be televised. Yes. Because they're calling to them for our audience that we're living in a modern world now. And especially cases that have to do with high-profile people need to be televised. That are some of the issues that they are raising. And they even give reference to the Supreme Court in case cases that they have been having in recent times, that the case that have to do with the impasse at the House of Representatives, they were all televised. So it is based on this, they are pushing this argument at before.
They even cited the activities there at the National Election Commission.
Exactly. So,
yes.
So they were based on the, their citing on it. But there is a rules of code, especially governing circuit codes in the country, and even magisterial code. But televising, and I just gave you an example of the silver mining case that were involving former House Speaker Eddie Stanners and Senator Barney Sherman. The same state, those that is even the former speaker, yes, who is now on trial on multiple offenses, was the chief prosecutor in that case during the Ellen Sedi Johnson's administration.
Okay.
And Arthur Johnson was one of the contracted lawyers who were in that case. They made similar application as criminal could see for the case to be televised, and that application was now based on the law that govern the rules of code, especially circuit code. So definitely, I mean, you will expect the lawyers not to be happy. And one good thing they always say is that the rules of code, you will always find the defense lawyers saying is that they are representing people of integrity. So they will do everything possible to make sure that the client gets the best legal representation. So all the things you see here is something normal. And you know, we are still we are a little bit far from getting to where we need to get in terms of for the defendant to be arraigned in court, so that they can plead to the indictment with a not guilty plea, because certainly they will be not guilty. So joint issue with the state.
So many at this stage, we are still in a preliminary stage.
We are still in the preliminary stage. We are still in the preliminary stage on the issue of pre-trial motions.
Okay.
Because what all they are propounding to the court are all pre-trial motions. Like for example, the issue to suppress evidence, that one is still pending. They came up with the one that they won for the court to televise. That was done with. Even they even filed a motion for the judge to recuse themselves. And then they even accused the court of keeping the client in jail perpetually.
Yes.
Though the court has ruled on that, but we are getting there. The good thing I know is that it will reach to a point where the indictment will be read to the defendants, and definitely will plead not guilty. All the offense that is in the indictment allow the case to prove the case against them consistent with law. They believe they have a strong defense team, but having a strong defense team is one issue. But looking at what has been presented to them, if they see some flaw into this team, especially the evidence, they have to make submissions to the court. And in these submissions to team, they will be going for it. Because at the end of the day, the Supreme Court, which is the higher court, if at all they get a verdict against them, the Supreme Court is the one that will be looking at the determinations of what happened in the lower court. So the Supreme Court will be reading all these pre-trial motions that have been filed by the defense team, because the defense team is the weaker vessel. They still have one way in this matter. If they go for a full trial, that will just inform our public, where the state begin to produce the evidence that they have in the possession, that they are almost submitted to the state, to the defense team, even though they have some problem with it. If all of the things come to an end, where they reach a point that the court will say, yes, we can now go into a trial, and the defense team agree based on all the motions that they filed, and then they didn't get result for that. If they are going for that, they still have only one way, and that one way is to go to prove the case. If they slip and then it go in the defense favor, that means they are an acquittal already. Definitely the state can take a plea, but only the defense can take a plea. They are the weaker person. So they are doing everything possible to make sure that to impeach on the credibility of all of the evidence that the state is bringing. And the state is aware of what the defense team is doing, because like Pastor Richard Scott is now the chief prosecutor of Colorado County for one of the defendants before. So he knows, so he have that defense strategy, and now going to prosecutions, which of course he have to. So he said, so he believes that everything is easy for him, especially in this case. So he's not trouble. As he continues to say, he's not a guy that most of the time when we get into an interview, he says, no, I don't want to do interview. Great. What I will say, even will be done in court.
Great. So last Tuesday, when we appeared here in court, the issue of sodomy and torture was proffered by Councillor Arthur Johnson, who he is a lead lawyer.
Before you go too far, I think that is what was raised in the motion.
Yes.
The motion to suppress evidence because they said that the defendants, the clan will torture state security to extract evidence for them. And that is why they are questioning the credibility of the evidence and they want for the evidence to be excluded. They want for the evidence to be transferred by the court. So, according to Judge Willie today, who had to agree on this matter, on the motion to suppress evidence, he said one key thing that he observed from what all the prosecution account before the court was the issue of torture in Solomon. So it is based on this. He won a medical report, he won a medical examination be done on the defendant before he can make a sound ruling into this matter. And he said that he want for the report to come in on or before the 9th of September and then on the 10th they can have a ruling, even though the defense team have interpreted that they said that they want an independent examiner to do the examination on the clan in order to have a free and fair and transparent examinations in connection with that. But they could have already ruled, yes, he took an exception, maybe they could run up, they could run up on that matter. So let's wait and see. But it's still far, we still have far way to go looking at the way things are proceeding in this matter or here.
At this stage where the defense team is asking for independent medical practitioner to examine the defendants who are currently in jail that said they were tortured by government and by prosecution. Who underwrite the cause? Will it be government to underwrite the cause, or will it be a defense to underwrite?
When the court gave a mandate, it's the government that underwrite the cause for transparency, and that is where the defense team have problem with. That is what I say they have remedy. Or if the judge rule, the only thing you have to do is to take an exception. And when you take an exception, you know what to do. That's why I say probably they will go on a revealer rate for the judge's decision. So only the Supreme Court can change the judge's decision. But if the judge rule, the judge rule. Because their argument is that JFK is a government hospital. They believe that the medical president there is not credible enough to do the examination on their clan because they are going against the government. It is a government institution. So these are some of their fears. So this is why they are calling for an independent. And if all the Supreme Court, if all they having to go before the Supreme Court, and the Supreme Court, we are just seeing a summary of a meeting. If the Supreme Court rule in the favor, the government is the same person that want to honor the court. Just in case for this independence, because maybe they could push some of the argument, in that line. Because you listen to Councilor Arthur Johnson. Yes, okay, we agree. Though you don't rule today, but we want an independent examiner to look at our clan, not the JFK Medical Hospital, which is a government institution.
Great. So, Mr. Tobe, as it stands, we say the ruling might not be possible on next Wednesday, or it will be possible. Because Councilor Arthur Johnson.
No, it will be possible. It will be possible, except where, as I said, except where they are taking flight. The article said to the Supreme Court and before the judges in chief with a petition. And that's the time we get to know whether the judge will proceed with what they will place on the ruling or not. But the ruling will be heard, as the judge announced in court that the medical report should be in on or before the 9th of September. Definitely will be in, and then on the 10th you'll be able to do, except for any circumstances that probably the medical practitioner may have, and then you will put that on the system. After the 10th, except for the defense will take flight to the Supreme Court.
Thank you so much, Mr. Tobe. Any final will take leave?
Thank you very much. With pleasures, and we hope that this trial will go on smoothly as we all anticipated that we see it, and we are doing this. We should not be, we should be straight as to what is obtaining in the court and not to put our own feelings in this matter. And thank you again, you're busy.
Thank you. So, folks, you have the earlier on listening to Fabien Kuya, the usual reporter for State Radio, followed by Mr. Peter Tobe, who have been here for a couple of years reporting on legal matters. So folks, we will be here next Wednesday when we will review the ruling of the 33 count motion filed by Arthur Johnson to suppress the evidence submitted by the prosecution team, Regis Scott, Council Augustine ceasefire. Thank you so much for being here. Are you happy? Keep following LNTV Liberia as we go through this soon in subsequent time. I'll be here. Aaron Talu bringing this live. Thank you so much for following National Television.